International conventions. So this presentation will be about international conventions, their application specifically in relation to corruption and Ghana. Now, for this presentation, you will have to use the website. So I would like you to turn to the conventions page, please, on the website. And there you will see under the presentations heading, International Conventions short version. Before you click on that, just so you're aware, the International Conventions long version is a longer version of this presentation, but we'll go into more detail. So that PowerPoint presentation has specific references to other articles that are more detailed in relation to international cooperation and other conventions that I will discuss in this presentation. But to say the short presentation is more focused and is a headlines in relation to your knowledge for international conventions. So please, if you can click on the International Conventions short version, please. Keep the website open because we will be making reference to other documents that are contained in the website. For example, the Corruption Compendium, which is on the conventions page, and also we will be looking at your legislation on the legislation page, the Criminal Code 1960, Act 29, and the Mutual Legal Assistance Act of 2010. So you may want to have those documents open now, but I will refer to them during this video presentation. So hopefully now you have the International Conventions short presentation title page in front of you. If you can go to page 2, please, headed Written in Stone. And certainly whenever I look at the law, I'm always very curious to understand the derivation and the history, the jurisprudence in relation to the law. And then I can garner a greater understanding of its application. So I've headed this title Written in Stone because that was the first ever treaty. The first treaty, as you'll see from this slide, was a border agreement between the rulers of the city-states of Lagash and Umma in Mesopotamia, so modern-day Iraq. And it was following a war in 2550 BC, and the two city-states signed this treaty on stone and was a marker post between the two states. In essence, the hieroglyphics represent that one state had to pay the other, the benefactor, a rent in relation to accessing their territory. No surprise that the treaty didn't last that long, but it was a symbol of the history in relation to treaties that there could be a written agreement. So the essence was a contract. One state agreeing with the other certain terms. And that's what we mean by treaty. Of course, in a domestic context, we would have treaties between commercial parties, no different in relation to a treaty between two states. They're committing to certain obligations between each other. Now you'll see the second bullet point relates to the first Geneva Convention of 1864. And I wanted to give you a bit of background as to what a convention was in comparison to a treaty. So this was the first convention, the first modern convention, and it was an agreement between multiple parties. And that is the difference, the essential difference between treaties and conventions. So a convention is a multilateral. So it's more than one state, more than one party agreeing to the same obligations. And in this sense, it was an obligation to respect the rights of those on the battlefield, those in relation to conflicts, armed conflicts and victims. and it was to stand the test of time. The Second Geneva Convention was many years later, but it set a model of good practice that numerous states could sign up to the same contractual obligations. You can now go to slide 3, headed Key Terms. So I wanted to give you a better understanding in relation to some of the essential terms for a convention. So if you were to go to your website, you can see on the conventions page that I have the United Nations conventions, the relevant conventions for the purposes of Ghana. So you have the UN Convention Against Corruption, otherwise known as UNCAC. And then you have the UN Convention Against Transnational Organised Crime, otherwise known as UNTOC, both of which Ghana is a signatory to. So what does a signatory to mean? Well, in essence, it means that the convention is open for a period of time from the first date it was signed, and then there may be a period of 6 months, less, or a year, 2 years, more, in which your state can sign the convention. And you see it on your conventions page of the website. There is a link to status under UNCAC. If you click that, you'll go to a web page which will be constantly refreshed, confirming those states who have signed the UNCAC. And you can see signature at the top and the country reference. And if you go down to Ghana, you can see that Ghana signed UNCAC on the 9th of December 2004. Again, if you go back up to the top of that status table, you will see ratification acceptance with a capital A, and then approval, accession and succession. So I want to explain some of those other terms. So ratification, first of all. So ratification means that a state has signed the convention, and then domestically they have brought the convention into their domestic law. Now there are two approaches in relation to how that is done. There's a monist approach and then a dualist approach. As a Commonwealth country, Ghana is a dualist approach, and in that respect Parliament has to agree the terms of the convention. And that has been done, and you can see that Ghana ratified, if we go down the status table again, on the 27th of June 2007. I can also show you in your website that if you go to the page that is listed International Guides, and you will see Ghana as a heading and the Ghana Treaty Manual. If you click on the Ghana Treaty Manual, you will see that this is a text that refers to exactly how Ghana ratifies any treaty. And there you go on page 6, it confirms in relation to the instrument of ratification and exactly what has to be done by resolution of Parliament. So please, you can read that document in your own time. If we go back to the presentation, and you can see reference to accede. Now again, if I go to the status page in relation to UNCAC, you can see, for example, Antigua and Barbuda. They have acceded on the 21st of June 2006. The Bahamas, 10th of January 2008. Bangladesh, 27th of February 2007. And you can see there's a small a, but what is missing is the signature date. And the reason for that is because exceeds means that the date for signature has expired. So there was a date by which all could sign the UNCAC. And you can actually see that the convention was adopted, and this is written above the status table, on the 31st of October 2011. And it remained open for signature from the 9th to the 11th of December, and then at the UN headquarters in New York until the 9th of December 2005. Ghana, you will recall, actually signed on the 9th of December 2004, so a year before the end of the period for signature. And exceed means that the countries have made sure that UNCAC applies domestically, but we're out of that period of time to sign. So they have exceeded. So going back to Antigua and Barbuda, they exceeded on the 21st of June 2006. They didn't sign before the expiry on the 9th of December 2005. So they have exceeded. In international law terms, it means exactly the same in essence as ratification, because it has become part of the domestic law, and equally, by exceeding, Antigua and Barbuda agrees to exactly the same obligations, terms and conditions as Ghana, who signed and then ratified. So please, in relation to the two terms, they are effectively the same, but they are different methods by which a state will confirm that they are obliged by the terms and to keep to the terms in relation to any international convention. So what is the purpose of a convention? Well, you can see on slide 4 that it brings the fight against international corruption to the political forefront. So when the international conventions are either signed, ratified, acceded to, politicians, that will be a political statement that we are standing up against corruption. We are agreeing with other states, one, that there is a problem, but this is how we can monitor and evaluate, and equally we are obliged to make sure that we keep to the terms of the convention. And that's why it sets legally binding standards, so that all of the signatories can be held to account. So you may well see in conventions that there are enforcement authorities, or more often making sure that assessments are done to make sure that states are keeping to the obligations that they have signed. One of the other main factors will be in relation to ensuring that there is international cooperation. So I was the UK liaison magistrate to the United States of America, and we would, as a signatory to UNCAC, we would make sure that if we had any other international arrangements, cooperation, that we would react and work with the other states who were signatories to UNCAC. So there may have been money going from Eastern European states into the United States. Whilst we may have had a bilateral treaty with the United States, if we needed to work with that third party state and they're a signatory to UNCAC but didn't have a bilateral treaty with the United Kingdom, we could use UNCAC as the basis for international cooperation to recover stolen assets, to garner evidence, and maybe even in relation to extradition. So if we move on to slide 5, I wanted to discuss about the enforceability in relation to conventions. And of course, conventions can be global, but they can equally be regional. And I'll discuss about 2 of the regional conventions: the African Union Convention Combating and Preventing Corruption, and equally the ECOWAS Protocol Against Corruption. Now, in relation to ECOWAS, it isn't enforced yet. It requires a certain number of states to sign for it to be in operation. But as part of the foundation of ECOWAS, there was a community court of justice established. And this has been very important to hold states to account in relation to obligations, and specifically I'm going to refer to a case involving corruption. So this is the matter of SIRAP against Nigeria. So SIRAP is the Socio-Economic Rights and Accountability Project. And you can see a summary in relation to this case on slide 5. Now, SIRAP submitted a petition to Nigeria's Domestic Corrupt Practices and Other Related Offences Commission in 2007. And they concluded that 3.3 billion Nigerian naira, or US 21 million US dollars, had been lost between 2005 and 6 in relation to the over and illegal utilisation of funding that should have been used in relation to primary education for Nigerian children. Albeit the Commission had decided that there was nothing that could enforce the Nigerian state to repay that money. So as a failing of the Nigerian state to recoup that money and make sure that it was now used for its primary purpose of education for children, SIRAP went to the ECOWAS Community Court of Justice. And there, in a landmark judgment in 2010, the Community Court of Justice upheld SIRAP's submission that the Nigerian government had a legal responsibility in relation to providing free, high quality and basic education to every Nigerian child. And on the basis of this massive corruption, they hadn't sought to enforce the Nigerians' Corrupt Practices and Other Related Offences Commission conclusion about the misappropriation of that money. Now, whilst that wouldn't be an enforceable decision, it set a clear benchmark and also made sure that there was international attention brought to this clear corruption and failing by the Nigerian state to account for that money and reconcile it back for the purpose that it was intended in relation to primary education. So here there is an example of how a convention and the court that was established as a result would send out a clear message in relation to international obligations. Whilst it couldn't be enforced, it set a clear judgment for a framework to work with anti-corruption agencies in relation to ensuring effective prosecution and ensuring that the Nigerian state kept to its obligations. If we now go to slide 6, and one of the key aspects in relation to any convention is establishing definitions. And of course, what we're looking at in this presentation is corruption. So where within the regional and also the international conventions is there a definition in relation to corruption? Well, the short answer is there isn't a single definition in relation to corruption. But what the conventions do are list offences that equate to corruption in its many types and forms. So, by way of example, UNCAC Chapter 3. Now with this, we're going to go back to the website. And on the menu, if you click the conventions, you will see down the bottom of that page, there is reference to the corruption compendium. And I've also listed underneath, you can see there's a list of all the major conventions in relation to corruption, and there is a page number next to each. So we are going to look at UNCAC, which starts from page 21. So if you click the corruption compendium, and we're going to go down to chapter 3, which should be from page 35, please. So on page 35, you can see Article 15, bribery of national public officials. And then there are offences that go through to Article 25, but just running through their titles. So bribery of a foreign public official and officials of public international organisations. Embezzlement, misappropriation, or other diversion of property by a public official. Trading in influence. Article 19, abuse of functions. 20, illicit enrichment. 21, bribery in the private sector. 22, embezzlement of property in the private sector. 23, laundering of the proceeds of crime. 24, concealment, and 25, obstruction of justice. Then let's look at the African Union Convention against corruption. So if you can now go to page 121, where that convention starts in the compendium, and we are going to specifically look at Article 6 to 10. So, and they will be on from page 122, I believe. Let's check. So turning to 122. So here we have, if we go back to 121, you can see that there is an Article 7, fight against corruption and related offences. And it starts to list the offences there. And then there's Article 8, illicit enrichment. And again, in the ECOWAS protocol, Article 6, which is on page 214, the convention starts, or the protocol starts on 211. But again, if we went down to 214, you can see how that protocol again lists from Article 6 the different types of offences. So now I would like you to look at your criminal code. So you can find the criminal code again on the website. And remember, on the menu we had legislation. If you don't have it on your book in front of you, then you can access it on the website, Criminal Code 1960 Act 29. And I would like you to go down, please, to page 113 or section 239. And there you have the definition, or you have the offence of corruption, and the explanation is at section 240. But what you will see through the sections that go section 239 all the way through to 254 are the definitions of public officer and juror. What you don't see is, you'll recall within UNCAC chapter 3 are references to foreign official, to the private sector. So with that in mind, again, we can go back to the website, and if we click onto corruption, you can see the Criminal Law Review Committee, and there are proposals on amendment of your corruption legislation. So this will be looking at how UNCAC Chapter 3 can be consistent with your own legislation. Because at the moment, you'll see from Section 240 that there is reference to being influenced by a gift, a promise, or prospect of any valuable consideration. And what the amendments are looking at are corruption in the round that isn't just in relation to influence, isn't just in relation to the receipt or otherwise of lawful consideration, isn't just in relation to a public official. So it's widening the scope and making it easier to follow in relation to corruption. And that is the direct influence of an international convention in relation to your domestic law and procedure. One other important point in relation to the corruption page on the website. You'll see right at the bottom that I've put a corruption dictionary. And we've talked just in relation to these definitions about embezzlement and about other forms of corruption, undue influence, illicit enrichment. So within the corruption dictionary, these terms are defined. It's a dictionary that's produced by another international organisation, but I feel it would be of benefit to give you a starter in relation to what many of these terms mean. So we're now turning back to the short presentation, International Conventions. And we're now on slide 7. And I referenced in terms of my specific role about international cooperation, and where I would use conventions in relation to corruption investigations for international cooperation. So by that, I mean mutual legal assistance. So sending a letter of request for evidence that will be in another state. Extradition to secure the return of an offender. Joint investigation teams. Very important in relation to saving time for investigations. Corruption investigations can be complex in terms of audit trails. They can be very straightforward in relation to a corrupt police officer leaving the jurisdiction and using international cooperation for extradition. But there can be those that may involve heads of state or high-level foreign public officials that may be located in other countries. Audit trails and the proceeds of criminality may have gone through many jurisdictions. A joint investigation team will bring law enforcement from these other jurisdictions together to ensure they can work together effectively. So a joint investigation team will be members from law enforcement from these other states, and an agreement will say who will be the lead officer and what they can and can't do in each respective jurisdiction. Very important in relation to making sure that roles are assigned. So on the website, in the International Guide section, there is a Model Joint Investigation Team Agreement. And in that agreement, there will be reference to who is the lead organisation and what are the powers that can be used in relation to any investigation to shorten the time and make sure people are working collaboratively. So I wanted to take you to some example provisions where your law does in fact replicate exactly these provisions that are within international conventions. So your Mutual Legal Assistance Act does replicate many of these provisions. So, for example, under UNCAC, so we're now on slide 8. UNCAC can be used as the basis for mutual legal assistance, so securing evidence from another state, if you don't have a bilateral treaty in place. And that is specified under Article 46(7). So remember, look at your status page. If you don't have a bilateral treaty with another state, but they have ratified, acceded to UNCAC. Article 46.7 will allow you to use that as the basis in relation to securing evidence from another state. Now, another important route is spontaneous information. So, for example, you have information about assets being located in another state. There isn't a bilateral treaty with that state, but it's more cost-effective, efficient, speedier to prevent the dissipation of those assets, to communicate the information that you have to that other state so that they can ensure that the assets are not dissipated and they are frozen. So, Article 48 of UNCAC allows law enforcement in Ghana to contact the other state to say you need this information to prevent those assets being dissipated. And then we can ensure their recovery and maybe even their return to Ghana. So that is replicated, Article 48, in different terminology, but in exactly the same impact on Section 52 of your Mutual Legal Assistance Act. Again, you can secure a copy in relation to the Mutual Legal Assistance Act through the website menu page legislation. And on page 19, section 52, there is the possibility of disclosing that information. And it specifically says, section 52.1 says E, should probably be C, may lead to the tracing, freezing and confiscation of the proceeds of crime. A very effective power because money can be dissipated, lost at the push of a button. So in order to react quickly, this allows the mechanism to be able to provide that information. Joint investigation teams that we've discussed. Article 49. See your Mutual Legal Assistance Act, section 54. And that's on page 20. Equally, in relation to special investigation techniques, it may well be that there needs to be monitoring of accounts, monitoring of phone calls or computers in relation to live access of messages that are being sent. Section 53 allows covert investigations, and specifically in relation to the use of special investigation techniques. UNCAC allows this under Article 50. Your domestic legislation, because you have ratified UNCAC, allows this within the Mutual Legal Assistance Act, section 53. So you can see the impact of international conventions for your work in relation to corruption investigations. So let's take an example. So I've moved to slide 9. And this was an email that I received whilst in Ghana on August the 19th, 10:54 p.m. So there is an email from supposedly somebody in the Google Accounts team asking me to click on a link to learn more, to view my messages, because apparently a message was blocked. I get you to look where it says Google Accounts above my email address. You can see the address that has sent me this link, hbzwdngs@adet.com. Now that obviously is not an email from Google Accounts or the Google team. It's from whoever aditi.com is. That isn't the Google Accounts team. That's exactly why this email went into my spam. But if I pushed on that button and then access had been allowed to my account, or there was information in my account that led to my bank account details being provided to a cyber criminal and money gone from my account in the UK or another jurisdiction, what could be done by law enforcement? Well, immediately, if we go back to slide 8, the information could have been provided via Article 48 of UNCAC or Section 52 of the Mutual Legal Assistance Act to wherever the money had been accessed in another state to freeze the account in relation to anybody who had garnered that money. Or the information provided in relation to that other state, if the address or the location through the IP the Internet Protocol address was known for where this email had been sent from to make sure that further investigations could take place to investigate that criminality. That could be done instantaneously through the provisions that have come down from international conventions. So it's very important that you are aware in relation to how these conventions can be used for what might appear to be straightforward matters, but equally in relation to you garnering knowledge about the tools that are accessible to you. And very important to understand that some of these provisions, they may seem to be complex, but there will always be somebody out there who will be able to assist. Now, the Public Prosecutions Division have their own international department, and very important that contact is made with them in relation to understanding the application of this type of international work and what can and can't be done. So this presentation is very much to equip you with the starting point and the reference points in relation to what powers and the relevance of conventions to garner. So turning to page 10 in conclusions. So as I said at the outset, conventions are like contracts. So therefore, very much in the manner of a contract that you have with a private party, they are the agreement, the terms and conditions, so therefore the other party can be held to account. Definitions. Whilst we may not have a single definition in relation to corruption, you can see that the offences are listed, and that's very important in terms of the domestic obligations to make sure that's replicated in the law. Often the conventions will assist with guidance for drafters to insert the relevant application of conventions and the definitions within domestic law. And then importantly, we've already talked about just in relation to international cooperation, mutual legal assistance, special investigation techniques, asset recovery, extradition and joint investigation teams. And I wanted to show you this last slide. So Bob Marley, if something can corrupt you, you're corrupted already. And it's very important that we understand that those who are by nature corrupt, they won't just turn a blind eye, but they'll be actively involved in relation to corruption. And we need to all work together. And in terms of the methodology of this workshop, the lawyers can assist in relation to understanding the application of conventions and provide to the law enforcement, have you thought of spontaneous information? These are the mechanisms domestically which we have to do that. We may want to protect information or secure agreement that certain information won't be disclosed to another party in that other state, so therefore we should agree certain terms before we spontaneously provide. Or joint investigation teams. Have we considered what we could do for a joint investigation team, and asking for a template to be drawn by the lawyer and then working closely with law enforcement to make sure that the agreement is something that can work together. But remembering that we all need to draw together in relation to ensuring that corruption doesn't thrive, and inevitably it has an international focus, but don't make that a block to going and doing further investigation or a prosecution. You can very much use it as a strength. So please, I hope you can use this presentation to cascade to your colleagues, and you can use it as a training mechanism for others. So thank you for this time to present to you on international conventions and their application to Ghana.